Hi Dealer XT community. Came up on a website that I wanted to share with you guys. Make sure that you're aware of what some of these customer lawyers are accusing dealerships of and how they're advertising certain claims to your customers to provide them with a way to sue you. This name of this law firm is Vachon Law Firm. They call themselves this trusted name in California consumer law, and they specialize in lemon law. Now, many of you may think that lemon law only applies to new cars, but there is an exception under the California lemon law that allows customers to sue dealerships even on used cars. This specific article here is advertising whether you regret buying a as-is vehicle. And it goes on to explain to the customer that an as-is sale does not mean you have no rights. It's telling customers that even if you bought the car as is at a car dealership in California, you may still have some rights if the vehicle turns out to be a lemon. So don't believe the dealer if he tries to convince you that you have no legal rights whatsoever. The article on the lawyer's website also goes on to get into more detail as to why as-is sales don't protect dealers from fraud claims, saying that in certain situations, if the customer brings a fraud cause of action, they would essentially be trying to prove that the dealer lied to the consumer in order to convince him or her to purchase the vehicle. So these are those kinds of he said, she said claims. What's really important here is, in this example, essentially what the lawyer is advertising to your customers is that they're telling the customers that when they go to buy a used car, that there is certain terminology that must be attached to that vehicle if the dealer is selling the vehicle as is. So here the lawyer is advertising by saying that in order to properly label a car as an as-is vehicle, the dealership must attach a sign or label to the vehicle that has to have three parts. One is that it has to say that the car is being sold as is. Secondly, it has to say that the entire risk as to the quality and performance of the vehicle is with the buyer. And number three, if the vehicle proves defective after the purchase, then the buyer must pay the entire cost of any necessary repairs. Now, if you guys remember, up until a couple years back, the old buyer's guide used to have some of this language in there. But when the federal government changed the buyer's guide, a lot of this language went away. So if you don't have this language attached to the vehicle, it could create an issue for you if a lawyer like this would want to bring a lawsuit against the dealership. It is to try to avoid some of this stuff from even coming in would be to make sure that this wording is attached to the vehicle, whether it be through a sticker or a label, and we would put it next to the buyer's guide. So that way, when you're using your Dealer XT tablet and taking photos of the buyer's guide, you also have evidence that the sticker was attached to the vehicle at the time of the sale. So just make sure you're putting those stickers on there, and just remember, Dealer XT's got your back.